People versus Baker, case number 235250.
Sierra Coke can be people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Justin Baker.
Record reflect Mr. Baker present here in the courtroom today. This is the date and time set for sentencing. Mr. Baker, have you had a chance to go through the pre-sentence report with Mr. Thompson?
Yes, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
People have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I think that recommendation is appropriate. The court's familiar with the facts in this case. I'd ask the court to follow the recommendation.
I would just clear, Your Honor. I don't have any changes. I do believe it's an appropriate recommendation. From our perspective, we are requesting that it be concurrent sentencing. That would be the permanent outlook for us. So as long as the court follows current, that's what we're.
Thank you. Mr. Baker, was there anything you wanted to say? I did read through the report, so I'm familiar with the circumstances that bring you before the court here today. There's also a lot of information in that report about your background. So obviously you have an extensive criminal history that results in higher guidelines in the case. 5 months to 23 months. Given your status at the time of this crime, given your past history, and given the circumstances here, the court finds that the recommended sentence, which is 23 months to 4 years, is accounts for your conduct in this case and your past history. So the court is going to follow that recommendation and sentence you to 23 months to 4 years. The court is going to allow you additional jail credit for the time you were in Clare County. That's something that I think your bond probably should have been canceled. I don't think that's necessarily your fault that it wasn't, and so I don't think you should be penalized additionally because of that. So the court is going to allow you credit for 81 days rather than 4 days. The court is also going to order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and a state cost of $68. You do have the ability to seek an appeal of this sentence. Mr. Thompson, can you provide Mr. Baker with technology?
So Mr. Baker, go ahead and initial date that top copy. That's just indicating you received it. You leave with 2 copies. If you want to file those for an appeal, you can. That's just indicating you received. Today's the 4th. These are yours.
The record should reflect the court is taking
Thank you. Your Honor, can I run next door and do a probate hearing?
Sure.
Yeah. All right.
Thank you. We have a few minutes until this is the case.
Thank you.
We're on the record and Jamie Melon, case number 235217, the record should reflect Ms. Melon's presence here at the courtroom. Counsel Baker.
Eric Hope from the state of Michigan.
Jason Thompson, I'm an expert on Jamie Melon.
Thank you. Ms. Melon, we had a chance to go through the pre-sentence report and talk to
No, I haven't. He asked me if I did, but I wasn't.
have a chance to do that here today before we go
No,
forward.
no.
No. Mr. Thompson, are you aware of the report?
No, Your Honor.
Do people have any suspicions?
Did make a note that number 2 and number 3 had blanks for the rate per month that they were supposed to be paid. I think that was just a typo, but other than that, no.
Anything on behalf of people for help?
And I think the recommendation is appropriate. There isn't a recommendation for probation. She doesn't seem to do real well with that. I think the court should follow the recommendation. Thank you.
Your Honor, I think the amount of the sentence is within the court's discretion. I think the recommendation is consistent with that. I think the court could also consider just giving her time served. This is in the scope of things, pretty minor RNO. Ms. Melon was wanted on a warrant. Police came to her house. She was essentially attempting to hide under a bed. The police were able to find her very easily, just didn't really slow them down very much. All that closing sounds.
Ms. Mellon, was there anything that you wanted to say?
Yes. So these past months have given me the time to think about the choices and the mistakes that I made. I'm not happy about where my life is heading. So now I have a good goal and a good game plan to reach those goals and to make my life back on track. I just hope I'm given that opportunity to do so. Thank you again.
I did read through the report, so I'm familiar with what happened in this case. You knew you had a warrant, and if you just would have turned yourself in when the police showed up, probably wouldn't be here on this charge. It's a situation where you just made things worse, by trying to hide from something that you weren't going to be able to really hide from. Eventually, whether it was that night or some other night, you were going to get picked up on that warrant. So, just bad decision making. I hope that this is a lesson for you going forward, that if you have a warrant, there's no reason to add to what's already bad. There's some indications in the report that there was some physical resistance that's not serious and we continue the course, but turn this into something it really didn't have to. And so I think some punishment is appropriate. I think the recommendation is a fair recommendation. I think it acknowledges both your conduct in this case, also your previous history. So the court is going to follow that recommendation. The court is going to send you to jail for 50 days. You have credit for 82 days served. It's going to order that you pay prime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and $50 state costs. Because this is going to here, there's no written appellate rights. You won't get a paper explaining to you how to appeal the sentence. If you wanted to do that, you would need to request an appeal within the next 14 days. If you have more questions about that, you can ask Mr. Thompson to explain that process to you. That. Ms. Koch, is there anything further that we need to address for the record today?
No, thank you.
Mr. Thompson?
Nothing further. Thank you.
That's all for today. Ms. Mellon, you're about to keep going forward.
68 days out of Omni days credit.
2022-24.
People versus Kimberly Leland, case number 245281. If I could have counsel for your appearances on that.
Sierra Coke on behalf of the state of Michigan.
Thank you. I'm Jason Thompson, on behalf of the defendant, Kimberly Leland. Your Honor, I think my client is on the Zoom system. She called me. She's, well, indicated a ride, fell through. Away, the court appearance notice was in person. That's where we're at.
So I'm just curious, because it looks like her bond was revoked back in January. Did we reinstate her bond? How is she out?
She's never been picked up because they're via Zoom, I think.
Oh, okay. So there's still an outstanding warrant for her.
That, my notes say that there's an active bench warrant.
All right, so Mr. Thompson, yes, if you have contact with Ms. Leland, then you just need to notify her. She needs to come up here.
It was my understanding she was on the Zoom system. Or wanted to address
I don't know
her.
if she is or not, but I'm not
Okay.
gonna bring her in on Zoom.
Okay, I understand.
So if you can notify her that she needs to turn herself in on that warrant, whether that's today or some other day. Once she is in custody, the court will set this for hearing immediately following. Ms. Coke, any further on the record for this?
No, thank you.
Mr. Thompson?
No, nothing further.
Our next matter is at 9:45 with Mr. Shepherd, so we'll take.
Case number 83, the arraignment on bench
Record is versus Vinchell. This is case number 214820. Vinchell, you're before the court today for arraignment on some alleged probation violations. We've been made aware of what the alleged violations are.
Yes.
Okay. I need to go through a few things with you with regard to your rights. First of all, you have the right to have a hearing as to whether or not you did violate your probation as alleged. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford a lawyer, one would be appointed for you at public expense. Mr. Thompson is here for purposes of arraignment today. If you have any questions or need to consult with him. If you are found guilty of any of the non-technical probation violations, it could subject you to the maximum possible penalty underlying charge, which looks like understand all those things that I just stated.
2 years, Judge, 2-year felony.
2 years?
Yeah.
Okay. You understand all those, yes? Okay. You have to talk to Mr. Thompson about how you want to plead with the violations.
My understanding, Mr. Beach, I was going to plead not guilty at this time. There's potential for further charges. So I've advised to exercise his right to remain silent. He has requested court appointed counsel. Mr. Garrett will be appointed on this file.
Okay, so the court's going to enter not guilty plea on your behalf with regard to all of the alleged violations, and then we'll set this for a hearing before Judge Hunter. And in terms of bond pending that hearing, Mr. McDelda, any position on that?
Judge, I mean, with the charges, I do think some cash bond is appropriate. I would ask for a lower level, maybe 5,000, 10% or something to that effect.
All right, thank you, Mr. Thompson.
I think a low cash bond is appropriate. Mr. Beach has worked with the community. My understanding has been reporting a long-time resident. $5,000.
Okay, Mr. Vinchell, given the nature of your underlying charges, which do involve assault with conduct, given the nature of the alleged violations, the court finds that the recommended bond by Mr. Calva is appropriate to shield public safety and appearance at future hearings. So the court will set bond in the amount of $5,000, 10%, cash or surety, along with all conditions of your probation as the conditions of bond. And then again, we'll set this matter for a hearing, should be notified of the time of that hearing. And Mr. Johnson, if Mr. Ditchell doesn't have it, will be given Mr. Shermer's.
Logistically, that just depends on how quick he bonds out. There's cards next door.
I have,
Just, I have no contact information.
He was his attorney the other way.
you have this information, yeah, okay. Okay, thank you, that's all. Okay, People versus David Shepherd, case number 235179 and 5180. Reflects Shepherd's present here in court today. Mr. Shepherd, do you have an attorney representing?
No, I do not. I'm currently seeking legal counsel after I dropped Robbie from my last hearing.
Okay, you understand that you have a jury trial next week, correct?
Yes,
Are you gonna hire counsel for that?
yes.
Okay. Ms. Coker, we're ready to proceed.
We are ready to proceed. We've had lots of hearings in this case and frankly, lots of stories from the defendant. But we are prepared to proceed. Everybody is subpoenaed and we will be going forward with the jury trial next week.
Okay. So, Mr. Shepherd, I suspect you're gonna have a difficult time finding an attorney who's gonna be willing to take your case and go to trial in less than a week. So I just want to warn you that if you're not present with an attorney for your trial date I think it's next Wednesday, April 10th. If you don't appear, number one, the court will issue a bench warrant for your arrest. If you do appear and you don't have an attorney and you're not ready to proceed to trial, the court will revoke your bond and take you into custody at that time. So I just want you to understand I'm not canceling the trial date, and you're not just gonna walk out of here on Wednesday and show up and you're not ready.
Is it possible that I get extra time
No.
to seek an attorney?
It's not possible.
Okay.
This has been on the books since December. The last time you were here, you told me that you were gonna have the Bernstein or somebody at your law firm that's gonna be representing you. You had more than enough time to get a lawyer. We'll see you next Wednesday with your attorney ready to proceed with trial.
Okay, can I get any documents stating this? Just the paperwork for next week?
You've already been sent a notice of the date and time of the trial.
Okay.
Next Wednesday. Thank you. Our next hearing set for 10 o'clock, so we'll take a short recess. We'll come back on the record at People versus Castle, case number 225060.
Here, on behalf of the people.
Dylan Jaskowski on behalf of Mr. Castle.
Morning, this is set for a probation violation hearing today. Yes, here.
Your Honor, Mr. Castle.
A 2-count, Judge. First one's the technicals. Let me to read them.
I just want to make sure that I'm clear, because it looks like there were 2 and then did one get added, or is that?
I think we did an extension after that.
Okay.
That's probably maybe what you're seeing. Just the 2 counts, Judge.
Okay, so a technical for consuming alcohol and then a non-technical for operating while under the influence.
Yes.
Is there any offer with regard to?
No, Judge, I just asked that this be set for sentencing.
Okay, so Mr. Castle's going to plead guilty to both.
Yes, Your Honor.
Mr. Castle, can you come up to the podium, please? If you raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? Mr. Castle, you understand that you do have the right to have a hearing as to whether or not you violated your probation. You understand that by pleading guilty, you're going to be giving up that right. Also, by pleading guilty, it's going to subject you to the maximum possible penalty on your underlying charge. Domestic violence, second. That's maximum up to 1 year, if you understand that. So, with all of those things in mind, what is your plea to the probation violations today? Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything? It's your own free choice to enter this plea. Yes. Are you pleading guilty to these violations because you are guilty? Yes. Back on October 28th of 2023, were you on probation here in Crawford County? Were you aware that one of the conditions of your probation was that you were to not consume alcohol? On or about that date, did you consume alcohol? Were you also aware that one of the conditions of your probation was that you were to not violate any provisions of state law? Did you violate state law by operating a vehicle while under the influence of alcohol on that day? The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will accept your guilty plea. Want to set this for separate date?
Yes, Judge, he's actually being sentenced next Tuesday, I believe.
It's the 16th.
On his plea in district court. That would be good to gather a little bit more information before I make a recommendation. So yeah, I'd ask it to be set out a month.
Okay, so Mr. Castle will set this matter for a separate hearing for sentencing. Make sure that you stay in touch with Mr. Jaskowski prior to that as well as Mr. McFarland, okay? And I don't see Mr. Bickman connected yet. So we'll take another short recess.
I don't know. The writ was done.
Mr. Hayden, we know the status of Mr. Bickman is.
He was sentenced in Otsego County, excuse me. 2 year in jail, so he should be there. So I don't know what the status of the writ would be, but
Okay, I don't see a writ in here, so I'm assuming that they're not gonna be put on today. Do you want to reset this for a separate date, or how do you want to go forward?
depending on how busy they are, they might be able to get them in there if we call them. I don't know if they're by their own policies, if they need to have a writ to do so, I'm not sure, but
Okay, do you want to try and do that yet this morning?
I could try to call to the jail and see, what our options are.
Okay, okay, we'll just pass it then for now. And then matter is set for 10:15. Michelle says also going to be a Zoom hearing. I don't think that's- I got to that yet. Okay, sir, are you David Bickman?
Yes, yeah,
Are you able to hear me okay?
yes, yeah,
Okay. All right, we're on the record in People versus David Bickman. This is case number 204590. And Mr. Bickman, you're before the court today for arraignment on a couple probation violations. Do you understand why you're before the court?
yeah, I think it's just one.
Have you been made aware of what the alleged violations are?
It was just one violation, yeah.
There are multiple cameras or microphones there because we're getting a lot of you're echoing.
I'm just in a small, you want me to turn it down a little bit, maybe? Is that better, or is that?
That's a little better. I'm just gonna ask you to speak really slowly for me.
Okay. Okay.
So can you repeat that? Do you know what the alleged violations are?
I think it was just one, I thought it was just one violation, but yeah.
And I mean, it's two violations, but it's the same conduct. So you have a technical violation as well as a non-technical, but they both arise out of the incident with Cadence Bickman, okay?
Okay.
So I'm going to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you did violate your probation. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford a lawyer, one would be appointed for you at public expense. Mr. Thompson, are you here for purposes of arraignment today?
I am.
Okay, and we have Mr. Thompson here in court for purposes of arraignment. If you wanted to consult with him during the hearing today, just let me know and I can put you into a breakout room so you can speak with him if you need to. If you are found guilty of either the non-technical probation violation, then it could subject you to the maximum possible penalty on your underlying charge, which is going to be 7.5 years. Do you understand that?
Yes, yes.
Got any kind of chance to speak with Mr. Bickman about this? No. Mr. Bickman, did you want to have a chance to talk to Mr. Thompson about how you wanted to speak today?
Is that like my lawyer, or?
Mr. Thompson is a court-appointed attorney who is here for purposes of arraignment today.
Okay, yeah, I'll talk to him.
Okay. Mr. Thompson, can you sign in?
Yeah, I would sign into this court Zoom.
Correct.
Yes, I'll do that.
Okay, just 1 minute, Mr. Bickman, and then I'm going to put you into a breakout room with Mr. Thompson, okay? Okay, that room should be open now.
All right, thank you, Your Honor.
While we're waiting on that, Ms. Coker, are you ready on Mr. Michelle's?
Yes.
Mr. Michelle, are you able to hear me okay?
Yes, sir.
Yes. All right, and Ms. Wolf, are you able to hear me okay?
Yes, Judge, thank you.
One second, we're just having some audio difficulties here, so just 1 minute. Okay, we're on the record now. This is People versus Brent Michelle's case number 224992. Both counsel are, Ms. Wolf's present by Zoom on behalf of Mr. Michelle's. He's also present by Zoom for the Department of Corrections. We have Ms. Cope present here in the courtroom. This is set for a hearing today on defendant's motion to correct invalid sentence and request resentencing. Ms. Wolf, how did you want to proceed today? Did you have some moral argument that you wanted to make on the motion?
Yes, Judge, thank you. And I'll move further away from my computer in case that.
Are you hearing that? Are you hearing that? Double?
Hear the echo, yeah.
Did you adjust the audio?
Maybe mute the TV and have it come through the speakers only.
I didn't adjust the audio. And the other people today were.
Ms. Wolf, can you say something?
Yes, yes.
Okay, we're good. I think you got it fixed.
Okay.
Thank you. Okay, how did you want to make some moral arguments today? I'm sorry.
Yes, very briefly, Judge. I know I covered all of the arguments in my briefing. I did not receive a response from the prosecutor, so I imagine that there are things here that still need to be discussed. The first thing that I wanted to say is thank you for allowing me to appear by Zoom. I say it to every judge who allows me to appear. It's a 3-hour drive. And this accommodation really does help me practice in the communities that I want to practice in and do the type of work I want to do. So I appreciate it. As far as the motion goes, so I had challenged the scoring of one prior record variable, that's PRV3. I don't expect an objection to that. And obviously, you know, the prosecutor can answer, but that one, I think it's pretty clear that the 10-year gap rule precludes scoring anything for PRV3 from prior to 2021. So I think that does need to be rescored from 10 points down to 0. And the overall PRV score then would come down from a level E to a level D. And I don't know if the court would rather us go one by one, or if you'd like me to address all 3 offense variables now as well and then do them all at once.
I think it'd be easier for me if we go one by one. So Ms. Cope, what's the people's position on that?
She is correct. We pulled up for the 10-year gap. It does apply. It would change the guidelines to 19 to 38. That is the only one that I agree with her argument on, but she is correct on it. And I think we will have to have a resentencing based on that.
Okay, so we do have a stipulation in the prosecutor with regard to OB3. So then let's move on to your next one, Ms. Wolf.
Right. This is exactly what I anticipated, that we'd have some back and forth on the OV. So the first one that I had challenged was offense variable 9. That is placement of victims in danger of physical injury or death. And it was scored, I believe, at the max possible, you know, as it would have been if there was any placement in danger of injury or death. But there are not facts in the record, not from any of the hearings or in the pre-sentence investigation report, to suggest that anyone was placed in any sort of imminent danger of actual physical injury or death. I'm not reading anywhere in the pre-sentence investigation report or in anything that was said at the plea hearing where there was, you know, even an actual approach of my client, you know, to the victim. I believe, you know, all of these things pretty much occurred over the phone. And I did cite case law in my brief that's pretty on point. And that's the Melon case that says clearly the legislature did not intend for threats to be enough to support scoring for physical injury or death under OV9. Psychological fear, damage to reputation, damage to credibility, things like that are not scored under OV9. And so I do believe that that was scored at 10 and it should have been scored at 0.
All right, thank you. Ms. Cope.
The victim can and will testify at a resentencing about the things that Mr. Michelle's did to her. Before we got to the point where she got the PPO, he was threatening her on a daily basis. In the PSI, it doesn't talk about it because the amount of things that Mr. Michelle's did versus the amount of things that are in the PSI, that this doesn't even begin to touch on all of the crazy things that he was doing that led to this situation for her to get the PPO and then the egg stalking and then him running from the police, all that stuff. But he threatened to torture her both on the phone and in person. He talked about torture techniques. He threatened their son. He told her he was going to hurt her. Those are the messages that are referenced in the PSI. A lot of those things happened both in person and then escalated. They got the PPO. He wasn't allowed to have contact, and he continued these threats to her. She absolutely was placed in danger, as was the son, and I think that that was scored properly.
Okay, thank you. Ms. Wolf, any response that you wanted to make to the prosecutor's argument on OB9?
No, Judge, just again, I would reiterate that the case law is very clear that threats are not sufficient. There needs to be something more. So there is additional evidence to be placed on the record at a resentencing. Of course, we can revisit the issue, but as of right now, there's nothing on the record to score OB9.
All right, thank you. Your argument as to OB10.
All right, so OB10 that's pre-offense conduct, I believe, or exploitation of a vulnerable victim. So in this case, OB10 was scored at the maximum possible 15 points for predatory conduct. However, predatory conduct is a little bit of a term of art. It is specifically defined under the language of the actual offense variable in the guidelines and in a lot of case law. The plain language of the sentence guideline itself says predatory conduct must be pre-offense conduct. And it also, that's in the case law as well, that it's, this has to be something that occurred before the offense in this case. So the aggravated stalking in this case, as it is charged in the felony information and as described in the pre-sentence investigation report, aggravated stalking covers all of the conduct that has been outlined in the charging document and in the agent's description of the offense in the PSI. So there is no pre-offense conduct on the record anywhere in these proceedings to warrant, the scoring of 15 points for predatory conduct, which would have had to occur prior. So for that reason, I do believe that scoring OB10 at 15 points was inaccurate.
Thank you, Ms. Coe.
Your Honor, I believe defense counsel is incorrect. There was a lot of pre-offense behavior in here. And as I said, they didn't outline the entire marriage that got to the point of the PPO and then the offense. But she got a PPO based on his behavior, which then led to the aggravated stalking. There was all of the pre-offense behavior just before it that led to her getting the PPO, which was sufficient to grant a PPO. And then he continued the behavior. We led into ag stalking. She certainly can testify to those things. And I believe this was scored properly.
Thank you. Ms. Wolf, any response you wanted to make to that argument?
No, Judge, I believe we've made the arguments. I'll leave it to the court's discretion.
Okay, thank you. And then finally, as to OB13.
All right, OB13 is a pattern of continuing felonious behavior. In this case, it was scored at 25 points, which again was for 3 or more felonious crimes against a person. And I've looked over the prior record in this case, as well as the charging document in this case. And I am unable to come up with 3 or more crimes against a person, felonious crimes against a person, to warrant the scoring of 25 points. And honestly, Judge, if it's helpful to the court, I'd like to hear the prosecutor's response to that first, because I feel that I might be missing something.
Okay, Ms. Coe.
This is probably the one I disagree the most with defense counsel on. When she puts in her response that a violation of a PPO is she talks about what the violation of a PPO is. That is correct. But when you violate a PPO, it is an ag stalking. So every time that he violated after this, every single one of those contacts is an aggravated stalking. And they just went on and on and on. I can't remember the numbers, but even when he was in jail, like the amount of things, and maybe what she sees, and I understand she's the appellate attorney, so she doesn't get what we had originally, but the amount of times that he violated after was astronomical. I think this is probably one of the worst cases I've ever seen. So to say that there wasn't a pattern, I mean, every single one of those I think there was probably 100 of them. And Miss Mary Ellen talked about them at the sentencing and all the things that he had done. Some of them are put into this PSI, many of them are not, but this one was scored correctly, I believe.
All right, thank you. Ms. Wolf?
Well, so when I'm looking at the prior record here, I see some controlled substance offenses from 2021. And then in this case, there is one felonious act, the aggravated stalking, and then one other one that was charged, computer use to commit crime against, or that's a 2 to 4 year felony as it's described in the information. The other two charges in this particular case were both misdemeanors. Violating a personal protection order is not a felony. All of the, individual various contacts in this case, all of them together supported the charge of aggravated stalking. That's one criminal offense. And so in this case, I don't see, Judge, that there is more than 2 possible crimes against a person for purposes of scoring OB 13.
Okay, thank you. Ms. Wolf, were there any other arguments that you needed to make today as to your motion?
No, Judge, just those 4.
Okay. All right, so what I'm going to do, the court is going to order that this be set for resentencing based on PRV 3 alone. I think Mr. Michelle's is entitled to a resentencing hearing under the court rules. So the court is going to grant the motion number 1 as to PRV 3 and order that this be set for resentencing. Ms. Wolf, there's always, I think, a little bit of confusion. I think technically or strictly speaking, you are not required to be counsel for the resentencing. But I have had appellate counsel appear for resentencing hearings in the past. Do you want to remain the attorney of record, or do you want to cede that back to appointed counsel for Mr. Michelle's?
Oh, no, Judge, I would be happy to handle the resentencing hearing.
Okay, so then what I'm going to do, we've got your arguments preserved for the record here today. But I suspect that there may be additional information as to the challenges to OB 9, 10, and 13 that the parties want to address at sentencing as well. So the court is going to hold its ruling as the OBs in abeyance and allow the counsel to make any additional arguments that they want to make based on any information that they're able to obtain between now and the resentencing. Again, preserving the arguments that were made here today. If counsel chooses not to add any additional arguments, the court will just rule on the OBs at the resentencing hearing, and if not, again, the court will allow additional argument based on new or different information that's obtained between now and then. So essentially, the court is again going to hold off on ruling on the OB challenges until the time of that resentencing hearing, at which the court will rule on those, will adjust the guidelines accordingly, and then all parties will have an opportunity to allocate based on new guidelines. So that's how we'll proceed from there. Ms. Wolf, if you could prepare an order just reflecting what I've just indicated, both with regard to PRV 3, the resentencing, and the OBs, and submit that either with a stipulation as to form or under the 7-day rule. And then the court will send out the notice of date and time for the resentencing hearing. The last thing that I want to address on that, Ms. Wolf, I don't know if you've spoken to Mr. Michelle's about this or not, but whether or not he wants to be physically present here in the courtroom in Crawford County, obviously he has the right to that. And the court would sign an order having him transported here for purposes of sentencing, or he can waive that right and we can proceed by Zoom like we're doing today. So Ms. Wolf, I don't know, you know how Mr. Michelle may want to proceed.
We haven't had an opportunity to discuss it, Judge, but usually in most of these cases, myself and my client both prefer to appear in person for a resentencing hearing. But so we'll put that as an in-person appearance. And if I have different information within the next 7 days, I'll let the court know so that we can prepare accordingly.
All right, so we'll set it as an in-person hearing. Ms. Cope, you can prepare a writ for that.
We don't normally do the post-conviction writs, but I will have my staff do it. I do have a quick question for the court. We don't do very many of these sentences and the AG does the appellate stuff. For this, can I do a written response to the OVs and attach documents? And can the victim appear via Zoom if she does not want to be present in the courtroom with the defendant?
Yes to both. And Ms. Wolf, if you want to submit any kind of written response to Ms. Cope's filing, if you're welcome to do that as well.
Yeah, sure, Judge. Yeah, we'll file a sentencing memorandum.
Okay, Ms. Wolf, anything else we need to address for your side for the record today?
No, Judge, I think that's everything.
Thank you, Ms. Cope.
No, thank you, Your Honor.
Okay, thank you. Ms. Wolf, you're free to disconnect. Mr. Michelle's, we're going to disconnect from Department of Corrections.
Perfect. Thank you, Judge. Have a good afternoon.
Thank you. Mr. Bickman, are you able to hear me?
Yes.
Okay, we're going to recall Bickman. Mr. Bickman, did you have a chance to consult with Mr. Thompson?
Yes.
How does Mr. Bickman?
He is requesting that a hearing be set. He is requesting that counsel be appointed. He advises that he pled no contest in the Otsego matter, so he reserves his right to challenge it in this proceeding, and that's what he indicates he wants to do.
Okay, so Mr. Bickman, the court's going to enter a not guilty plea on your behalf with regard to the alleged violations. The court will set this for a hearing. Mr. Thompson is aware that you're requesting a court-appointed attorney, so counsel, do you know if he's going to qualify?
Yes, he qualifies. He's currently.
So counsel will be appointed for you and you'll have an opportunity to consult with them prior to that hearing, okay?
Okay.
Do we need to address bond? Are you currently under sentence there, Mr. Bickman?
Yes.
How long will you be there in Otsego County?
Till January 3rd, I believe. So like I got a year.
Okay, so so the court's not going to address bond based on Mr. Bickman's incarceration. Otsego County. Mr. Haven, anything else that we need to address that as well?
Not at this time, Your Honor. Thank you.
Absolutely.
Nothing further. Thank you.
Mr. Bickman, do you have any questions about how we're going to proceed in this case?
Didn't possibly know how long it might be till the next hearing, or
I don't have my docket calendar here, so
okay.
I can't tell you, but the court will get it on its docket as quickly as we can.
Okay.
Okay, thank you. That's all for today, and the court's going to disconnect from Otsego County. People versus Clone, case number 245291.
Sierra, can we have the people?
In this matter, the record should reflect Mr. Clemens present here in the courtroom. We had a chance to go through the reset report. Talk to Mr. Germer about that. Yes, I have. Mr. Germer, do you have any additions, deletions, or corrections?
Judge, the body of the report, there are some corrections that I'd like to address.
Okay.
But I think if I could address the scoring guidelines, that may adjust some of the body language.
Okay. That's what I didn't get a memo ahead of time, so I'm not sure what you're doing.
And I did do one because I think, and if I can just orally address, I think it'll make sense why one couldn't be done in writing, because there's no case law or anything other than what I would argue always supporting it. So Judge, Mr. Plum was scored on PRV 1 and was scored 50 points. When I look at what his high severity felonies are, they're from the same date and the same charges, same statute.
Okay.
So I don't think those two counts should be counted as two different charges. It indicates current charge, controlled substance, delivery, manufacture of cocaine, heroin, or another substance. And then it says the original charge, controlled substance, delivery, manufacture, cocaine, heroin, or another substance.
Which one are we looking at? I just want to identify, make sure we make it clear for the record which convictions you're talking about.
7 of 13, Your Honor.
It'll be 7 of 13, that's
Seven, okay, thank
the 2005 conviction.
you. Okay,
The statutes are the same transaction. That's how the statute is written. It says final charge is delivery of cocaine under 50 grams, period, cocaine under 50 grams. But it doesn't, that's the issue. So I scored as 1, which would certainly then be at 25 points. Department of Corrections has it as 2. When I spoke with Mr. Haven, I know he pulled out the charging sheets, I think, from the county where this occurred. And again, it says the current charge and the original charge, same statute. And that's what Mr. Cohn collected.
all right. Is it 2 separate convictions under the, I mean, you can have 2 convictions under the same statute.
There are 2 convictions, and the Department of Corrections record has 2 convictions as well.
And I don't see it as 2 convictions. It says current charge and original charge. So it doesn't say 2 separate convictions.
But Mr. Haven's telling me the records show that it's 2 convictions.
The paper that I gave him, Your Honor, were the final charges, and it says charges in parentheses above what must have been paid 1, in parentheses said 2 under charges for 38th Circuit Court.
Right, again,
Can I see what?
Sure.
What it says here. So, I mean, Mr. Gurmurthy, your argument's preserved for the record. I understand what you're saying, but what this looks like to me is under the same file number. He was charged with 2 counts. And that he was convicted of 2. So I see this as 2 convictions, therefore the court finds that it would be properly scored as a conviction.
and for the record, my client indicates that he recalls pleading to 1 count, 1 conviction. So I don't know if there's an issue with me. And I couldn't find any research supporting that it's the same transaction. It should be one count or counted once. It's under the same statute. But as the court's indicated, it is preserved for the record.
Yeah, and the statute says 2 convictions, and I appreciate what you remember. But what I'm going on is what it says on this paper, which is 2 charges under the same statute and 2 convictions. So statute says 2 convictions. Let's say other different language. So yeah, I'll put that back to you. But again, the objection is preserved. The court's obligation to object, and the court one remains squared.
Mr. Further, the report indicates on page 1, under the recommendation narrative, that OB1 scored 15 points as Michelle Kanoy reported the defendant pointed gun at her.
Okay, so we're challenging OB1.
I am. And then that's the body in the language of the report, and then we look at the language in OB1. 15 points, a firearm was pointed at or towards a victim, or the victim had reasonable apprehension of an immediate battery when threatened. Michelle is not a victim in this matter. That should not be scored, and it's improperly scored.
Okay, so
That's wrong. There was a fight at the house when Mr. Klum left. He pointed a gun at Michelle. I don't know that he thought it was Michelle. I think he probably thought it was Stephanie, but I'm not here to put thoughts in his mind. But what he actually did was point a gun at Michelle Kanoy. She is a victim. It is scored properly.
Because again, she's not a victim, and again, the supplemental report indicates no weapon was found in the house. That language from the supplemental report did not make it into the narrative in the agent's description.
Okay, all right. The court has to find that the scoring of a particular variable is supported by evidence sufficient under a preponderance standard. And so looking at the narrative, the description of the offense, which is taken from the police report, Michelle, Illinois, does claim that the defendant pointed a weapon at her. Looking at OB1, under the statutory definition, it says each person who is placed in danger of injury or loss of life is counted as a victim for purposes of scoring OB1. So I don't think the victim here has to be one person. It could be anybody who was placed in danger of injury or loss of life. If Mr. Bloom pointed a weapon at Ms. Noy or a firearm at Ms. Noy, then she was placed in danger of injury or loss of life, and she is a victim for purposes of scoring. I don't have any evidence to contest what she said, and so the court finds that her statements, by a preponderance, the evidence that a gun was pointed at her makes her a victim, and which makes scoring of 15 points under OB1 appropriate. So for those reasons, the court will deny the challenge. Any other challenges?
I just have one for, two more, Judge, OB4, and I'll leave that in the court's discretion. My only argument in OB4 is 10 points for sport for some serious psychological injury requires professional treatment. In this instance, I would just submit to the court that the parties were in counseling prior to any of these instances, or any of the incidents. The parties, I've been dating for 18 years, they were both in counseling, they were both going through treatment to reconcile and work through their relationship. I don't have any evidence that this incident then got her into counseling. There's any records that this is further in counseling. So I would again preserve that for the record.
Ms. Coke.
Your Honor, the victim, Stephanie, the victim in this case, has had a lot of psychological injury as a result of the continued stalking behavior that hasn't even ended with this case. He continues to do it while in the jail. And even after this case was charged and this case was going on, he continued these things to the point where there was a GPS found on her car. The police had to go out there with a mirror and get underneath there and find where him and his girlfriend had placed a GPS on her car. I don't think we can say just because she was in counseling before, she does not have psychological injury as a result of these horrific acts that he continued to do to her.
Is Ms. Gray going to give a statement today?
She was considering giving a statement. I don't know if she has decided that. Yes, she's going to speak today.
Then I'm gonna hold off on ruling on OB4.
Okay.
Great.
And then, of course, Judge, I have 5 points in OB17. I believe it's properly scored again as OB17 should only be scored if the offense or attempted offense involves the operation of a vehicle, vessel, or RV, snowmobile, aircraft, or locomotive under the statute. None of that applies here, Judge.
Mr. Gamuthi is correct. OV17 is for OWI thirds.
So the court will grant the challenges to OB17, score that at 0. Give this OB total of 31.
$95.
Yes.
Yes. What did it change?
24 months. What do we change to?
That is correct. Goes down to 12, yes.
Okay, so court will amend the guidelines 12.4.
And then certainly that would, I don't think that would then change the guidelines if, based on the OB4 ruling.
whether or not the court grants OB4.
Correct, I think the guidelines will remain the same, whether or not the court grants or before challenges. I'm just presenting that. to you. One second. Just want to respond to the comment that Ms. Hope made that Mr. Combs placed the GPS tether on.
Okay, that should be part of that.
Okay,
And, in the future, when we have this many challenges and ones that are gonna change guidelines, it's really helpful to have that memorandum. So that we're not all doing this on the fly, we're not trying to look up, all of this could have been laid out in a memo.
it could have, I agree. I just have any case law supporting those challenges because I think it was just on statute wrong, so.
Don't need case law.
Okay.
If you have facts, a lot of them are factual determinations.
Yes.
Just need to know ahead of time, not wasting time reading through books and adjusting guidelines on the fly. Please do that in the future, especially when you're talking about multiple guidelines challenges. So you have any corrections to the body of the report? Because we wanted to wait on until we have to.
I can make that as part of my allocution, because there are some two sides to the story now.
Sure.
Okay.
Ms. Coe, if people have any additions, deletions, or corrections?
Your Honor, no, not based on the record I have right now.
People have any challenges to the scoring?
It is possible that the court will consider scoring OV 13 after Ms. Gray speaks today for a continued pattern of criminal behavior. We actually ironically just argued that same issue in Mr. Michelle's case because of the things that have happened since this aggravated stalking happened, which included him following a CPS worker and then finding of the GPS. But I need Ms. Gray to testify before I can make that argument or to give her speech.
Again, if you're gonna raise this as an issue, it's helpful to know this ahead of time, because I think we're running up against a real legal question here, which is scoring OV 13 crime 5-year period, including the sentencing that's counted without regard to whether they have resulted in conviction. So, are we talking about all potential criminal activity, and am I supposed to make findings under a preponderance standard that the defendant committed other crimes that were not charged or the result of convictions? When I think of OV 13, I think of other crimes that were charged but were dismissed as part of plea agreements that didn't result in convictions. Because if you're going to say that the court can consider criminal activity if it finds by preponderance the evidence that the defendant committed that crime within the past 5 years, we're going to be talking about some extensive evidentiary hearings that are going to need to occur. If we're talking about crimes that were charged but didn't result in a conviction, that's something completely different, because we can look at information and we know what crimes were charged and weren't. So what's your argument going to be on that? Because if it's going to be that I can consider anything that the defendant did in the previous 5 years and make decisions on a preponderance standard as to whether or not any of those would qualify as felonies, we're going down a completely different road.
Yeah, I think it just, what I was not sure what she was going to say today in terms of what has happened since this incident occurred. I've talked to her numerous times, but I think she's going to give her impact statement. And
That doesn't answer my question.
I think he's committed additional crimes by putting a GPS on her car.
You're going to ask me to find under a preponderance standard that he's guilty of other crimes and then count those for scoring.
Yes,
And are you gonna start doing this in all of your cases? Because if we are, because 5 years is a long time, and the defendant could have done a lot of things during that time that you have anecdotal evidence of that were never charged, never investigated.
this,
You understand what I'm saying?
I understand. The reason I can't answer the question is because it hasn't been charged. I don't have the police report yet. It's still with the police. They have done an investigation on it, but they're searching, they're doing search warrants on the GPS. So the reason it hasn't been charged is it's new. It just happened. So I don't have the information. So I can't give it to the court because I don't have it. I only know what the police have told me. They haven't sent it over for new charges yet, but they are going to be.
Well, I'm not gonna consider OB 13 at this point. I don't think there's a legal basis to do it. You wanna have sentencing adjourned and you wanna brief this issue and we can get a ruling, then I'd be more than happy to do that.
No, thank you.
Was that the only variable that you want to challenge?
Yes.
So, Mr. And then would you like to have give a statement?
Ms. Gray.
Great. I know you've already said your name, but can you just for the record, please tell me your name?
I'm Stephanie Gray.
Thank you. And what is it that you would like to say?
Read it again anyways. You're both speaking here today because it's gonna upset Logan. I'm terrified that I'm gonna be in trouble if I say anything negative about him. I'm afraid of getting mad. I'm getting mad and trying to get some kind of revenge on me. But he's been mentally, emotionally, and verbally abusing me for 18 years, and I finally feel like I can say my piece. The night of November 19th, 2023, Logan had been intoxicated, taking my pistol and was threatening to kill himself. He did this in front of our oldest daughter and I. Our daughter was 16 at the time. He left the house and wouldn't answer any of my phone calls and texts, and we were terrified of what he might do to himself or us. We turned all the lights in the house off and locked all the doors and huddled together on the floor so we wouldn't know what room we were in. At one point, he kicked the door in, and our daughter had to call the police on her own father. Traumatizing experience for both of us. When he realized she called the police, he got in her face and told her that when he kills himself, that he wanted her to know it was her fault. When the police arrived, our daughter was watching as the police were yelling that if he didn't stop and get down, they were going to have to shoot. He wasn't getting down, so I told her to go to her bedroom and plug her ears. She couldn't sleep in her room for months after that. She slept with me because it brought back trauma that night. All the kids would bring their mattresses into the living room so they could sleep together because they were afraid. Since that time, there has been a no contact order in place for him and I. He would call the house numerous times a day and would yell over the phone to me. He would ask the kids who was at the house and what we were doing and felt like he was still managing our every move. He eventually bought our 6-year-old a phone and told us it was illegal for us to take it or touch it or use it, and told our 6-year-old to call the police if anybody did anything with their phone. He doesn't like one of my friends I have and screamed at her over the speakerphone to get out of his house, and he tried to have the police come and make her leave. For years, I haven't been allowed to have any friends, any friendships with anyone unless they were Logan's friends or he would approve of them, which he never did for long. He's micromanaged my life all day, every day for the last 18 years. He had to know where I was and what I was doing at all times. I haven't been able to spend time with a friend or my family without his approval. Suddenly he was telling me where I had been and what I was doing throughout the day. Later, I learned that he was following me or having me followed. He had sat across from my work with our youngest child, who was 6, to watch me. Then we found a tracker on my car, which is being investigated. I was terrified and always looking over my shoulder for him everywhere I went. I was afraid that if it was icy, that he'd run me off the road on my way home from work. He doesn't respect the rules that the court spelled out for him, and he's always finds a way to sneak around them. He had taken my 10-year-old daughter shopping for lotions and body washes and gotten the scent that I wear and told her that he wanted to be able to smell them because they smelled like me. He'd also started using laundry soap I loved that I was never allowed to use before because it gave him a headache. I told our 10-year-old daughter that it was because it smelled like me. I found this disturbing and kind of scary. Since he's been in jail, the 3 youngest kids had wanted to see him, so I drove him to jail for visitation. At the first visitation, he found out my friend and her husband had been to the house. They brought our oldest daughter a bed. He told the kids he was going to make sure that they weren't allowed at the house anymore. Logan had started to bribe the kids once they no longer wanted to see him at visitation. He started off by saying that he would get them ice cream if they came to see him. Once he realized it only worked for our youngest, he started saying get more expensive things like Sephora skincare, Stanley cups, or just give them money. He gave our youngest a coloring book meant to have stickers in it, but he ripped the stickers out and stated that he would give them to her at visits. Our son only went to 1 visitation and was so upset and agitated afterwards that he kicked a hole in his bedroom door. Our son's been in trouble a lot this year. On March 18th at school. On March 18th, one of his teachers had called me and stated that he didn't know what had been different, but that Shane had been the happiest and has had the best disposition for the last 2 weeks that he's seen him have all year long. 2 weeks is how long Logan was in jail at that time. I still don't feel safe anywhere. I'm constantly looking over my shoulder to see who's following me or watching me. I haven't been able to eat or sleep right since all this started. I have anxiety and feel like I'm having a heart attack all the time. From jail, he still knows who's been at the house. In the past, he's had friends and family watch me for him and pray for my safety. He called his kids last night and told us he's going to get married to a stranger that helped him track and stalk me, and told me if I sign a lease that his friend's going to bring for me that for his house, that he won't marry her, but he needs somebody to pay for his house. From what I've been told by some of his family members, he's told his family that I'm making up stories about allegations he's made to me, his probation officer, and his mental health workers against his mother to try to keep them against him, which is untrue, and I would never do that. I'm asking for the maximum allowable time for him because this won't be over for me once sentencing is over, because from past experience, I know he's gonna pick right up where he left off when he gets out.
Anybody else that wanted to address the court?
No, thank you.
Anything you'd like to say on behalf of the people for allocation today?
Yeah, this is a really terrible case. I think this is the only case that Department of Human Services has ever called me and like specifically asked to revoke someone's bond. He was waiting for them at the end of Stephanie's driveway and followed the DHS worker down the road, and she thought he was taping her. She said it was really scary, and he followed her all the way to Roscommon because she was in her private vehicle and she was in a truck, so it didn't say the state of Michigan. And then Mr. Klug started calling the CPS worker, but after she left Stephanie's house, saying, "All right, did you just leave my house?" While he was following her. I mean, these type of behaviors are so crazy. The GPS underneath Stephanie's car was registered to his girlfriend, who told the police that he put the tracker on with black zip ties. I mean, Stephanie was terrified, as the court could see now today, but she has been that way for the whole case. And even after we charged this, the behavior didn't stop. It actually escalated to the point where we were very worried about her safety. I think the high end of the guidelines is absolutely where she should be, where he should be sentenced at. And I anticipate additional charges for the tracker once the police have finished their investigation. Thank you.
All right, thank you. And for the record, given Ms. Gray's statement here, the court finds that there is factual support for scoring of OB for psychological damage. The court will deny the objection to that, which leaves us at final guidelines of 12 to 24. Mr. Germer, any allocution on behalf of?
Yes, Judge. The last time Mr. Crawford was in any criminal trouble was in 2015. He hasn't been in trouble since. What started this incident was his prescription of medication that attached to the letter indicated that he was suicidal. They increased the dosage when he called, and that really put him over the edge. Started this incident. Since then, Mr. Plum has engaged in counseling. He was in counseling until he was arrested. His bond was revoked. I would express to the court that Ms. Gray has only presented what her side of the story is, but there is the other side of the story where Ms. Gray would go to Mr. Clum's, at least drive by where Mr. Clum was residing with the woman he wants to marry, with the girlfriend he was dating, which there is videos of from her house that have picked up Ms. Gray traveling. They're going, they're sitting there waiting there, but she hasn't indicated those things to Ms. Cole. I've provided those videos. Again, it's two sides to every story. The GPS tracker was not put on by Mr. Plum, and Mr. Plum was not the person who was following the CPS worker or tracking the CPS worker. There was an affidavit that the CPS worker signed indicating that Ms. Gray never told him that. I've talked to Deputy Cladlaw to get the recording from the phone, because there was that conversation that's recorded where Stephanie Gray tells Logan that the CPS worker was just here and this is what she investigated and left. I've submitted a separate receipt where Mr. Plum was in a different area at the time that happened, wasn't even in the area. So there are, again, two sides to the story that Ms. Gray again has not indicated, has been forthcoming and telling what has happened. Even at the taking of the plea taking process before court, Ms. Gray had Mr. Plum come to the local gas station in town and meet him there before he was going to enter the court. So those things again, and again, there were bond violations that certainly the prosecution had filed. Again, the bond prevented Mr. Plum from having contact, and Mr. Plum certainly did violate certain conditions of his bond, and he knows that. But I think in full disclosure, there's two sides to what has occurred here. And I think what Ms. Gray's really ticked off about is that Mr. Plum indicated that he was going to marry somebody else. He's reached out to the jail to get the marriage. What of the guidelines are and what the court needs to do. I think she's already applied for a state marriage license. And I think all that said in that after 18 years, he didn't marry Ms. Plum and he was marrying somebody else. And I don't know what the social or family dynamics are, but that's all the evidence that I have that has led to where we are. There were some phone contacts initially, but Mr. Plum was calling his daughter's phone and the home phone to speak to the kids while the no contact order was in place. That then subsequently did get modified for the two parties to speak on app close, which is a parenting app, so they could communicate regarding the children. So I don't know if that was a violation at that point, but there was a modification to allow for contact with the children. There was an interim parenting time schedule and order that allowed Mr. Plum to get the children and Ms. Gray to then have the children at certain days and times and so on. So I think he's followed those rules once those orders were entered and processed by the court. I've submitted the letters that Mr. Plum again was in counseling, was seeing Mr. Carrigan, was set for a psychological evaluation. There is some underlying mental health issues here. I think Mr. Plum the letters I've submitted. So I would simply submit to the court that this is a straddle cell at this point. Mr. Plum has not been in any trouble in almost 9 years. And a prison sentence, I don't think is certainly warranted, given that there are two sides to the story. And I would also ask the court, if Ms. Gove is getting a search warrant, get the warrants for the jail calls, the conversations that have occurred. From what my understanding is, don't lead to the level of what Ms. Gray has indicated to the court, that he's stalking her or has people stalking her, because The house is in Mr. Klum's name. Mr. Klum has a power of attorney again with another friend who is processing certain things with regards to the house and so on. So I don't think that's stalking, but I think if Mr. Klum is going to be incarcerated, he has to take care of those things before his house goes into foreclosure or is lost on the market, so they can figure out whether it's up for sale or whether it's going to be rented. And he's taken those steps. So that's what I would leave the court to judge.
All right, thank you, Mr. Klum. Anything you wanted to say?
I apologize for my action and was getting mental health before this occurred. And after, I had 2 psychological evaluations I was set up for that I couldn't go to because my bond had been revoked. I know I have mental health issues and I would love to be able to get it taken down and get everything addressed. And I'm sorry I've ever hurt you or our kids in any way. I just apologize for my actions.
All right, I read through the report. In this case, I'm familiar with circumstances. Obviously, I read through Ms. Gray's statement prior to this, and I appreciate you. Not an easy thing for you to do in this case. Not an easy thing for any victim to do, and so I appreciate you coming forward and making that statement. I did receive the letters from your counselor, your doctor, regarding medication, and taking all of that into consideration along with what the lawyers had to say, which, I mean, there's been a lot said today about kind of the peripheral of your relationship, but we also have to look at what happened in this case, what brought you before the court, specific circumstances, which are very concerning to me. Anytime you combine alcohol and firearms, it has the potential for really terrible consequences. And I think everybody's lucky that this could end up worse than it did. And regardless of any underlying mental health issues, your actions during the course of this incident were completely inexcusable, and there's no reason for that whatsoever. Going on in your relationship or in your personal life doesn't justify doing what you did throughout the course of this incident. I think there's no question in my mind that Ms. Gray is sincere. She didn't appear to me to be making this up. Her emotions seem very sincere to me here on the record. She doesn't strike me as a woman scorned in any way. I think she's genuinely fearful of you and what you may do in the future. And I think that's based on her past experience with you. And I think there's legitimate reasons for her to be concerned. And I think there's legitimate reasons for the court to be concerned. And given your conduct in this case, I think that a sentence at the high end of the guidelines is warranted. Number one, to protect the community from you for a period of time so that you're not out and able to victimize her or anybody else. I think it's also justified as a punishment consequence to you so that you understand it's not acceptable, it's not going to be tolerated. The court is going to sentence you to 24 months to 4 years in the Michigan Department of Corrections. You do have credit for 28 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You do have the ability to seek an appeal of the sentence. Once the reform is out, proceed to this appellate.
Judge, for the record, Mr. Klum has acknowledged receipt of this.
You are remanded to the custody of the state.
I haven't seen my son in 2 years. Could I give him a hug before he goes
I'm
away?
sorry, you cannot.
Yeah, with this, yes.
Last case of the morning, People versus Thomas Hill, case number 245.
Here, on behalf of the people.
Thank you, already, bro. Mr. Hill is not present. Can I allocate? I did if you.
Yes.
Okay. Judge, Mr. Hill is not present. Mr. Hill called me yesterday.
Sorry.
Mr. Hill called me yesterday, Judge, indicating that he had car troubles and was in Detroit. He also spoke with Ms. Anderson, who confirmed the same. Mr. Hill is down there, and I spoke to him this morning as well, Judge, to confirm if that car trouble situation changed, if it was going to be late or was going to get a ride, I didn't know. And he was still down there and indicated that he was asked by Ms. Anderson to take a drug test. He was going to take that this morning and submit it. I don't know if that's been submitted yet or not. I'll talk to Ms. Anderson. Said it would indicate that the results would be coming from a Detroit area facility, which would show that he is still down there and that he was still having car troubles. It's a no jail recommendation. Mr. Hill has complied with all of the pretrial services. They kept in touch with me. So I would simply ask the court to just adjourn this matter, set up for a show cause rather than bench warrant. Mr. Hill was at the jury status conference. He was at both of his district court hearings, the PCC and the prelim date. Or maybe it was just the one that we bound over. I don't have the file right in front of me. But he was here, he was kept in touch with me, and that's all I can acknowledge the court. I'll report that I don't have any concerns with this non-appearance. In other words, I don't believe that he's evading coming to court.
Ms. Cove, do people take any position?
We don't have any information on any long history of failure to appears or anything. And the recommendation wasn't jail, which is usually why I think people don't show up. It was just probation. So I would be fine adjourning it.
This case, I believe, Harold Plata is for parents in certain court. He doesn't have any prior failures to appear that I'm aware of. This recommendation is for a time served sentence and probation. I did receive a report from Ms. Anderson, which I generally receive in sentencing cases, which indicates that he's fully complied with pretrial services during the pendency of the case. So there's no indication that he's purposely trying to avoid consequences. Given the nature of the recommendation, there isn't any motivation for him to willfully miss his hearing. So there tends to find that got reasonable justification for not making it today. The court will set this for another hearing for sentencing in about 30 days.
And Judge, I should just state for the record, but I did get an email from Ms. Anderson yesterday with the same comments as I indicated to the court. And she verified as well that he's having car troubles and emailed me regarding that as well. So I did reach out to both Ms. Anderson and myself, trying to scramble and figure out what today's purpose. So I want to make that clear.
Okay. All right. Thank you. That concludes our morning docket.
Thank you.